is the Central American Minors Program. Today we'll be giving you updates, information about the RFR and reparole. We have an all-star, really superstar cast of presenters today. We're going to try and move through this pretty promptly. We have a lot of our presenters have a lot of information to provide you all today. I'm Tony Kubey, the Justice for Immigrants National Manager, and just a couple of housekeeping items before we begin in earnest. On the left-hand side of your screen is a chat box, and I'm going to put a note there. That's where you're going to ask questions. If you have any questions for the presenters, you folks are in listen-only mode, and as we're moving along, I'm sure you'll have some questions. So please go ahead and type those in the chat box. First off, I want to thank all the presenters today. These folks are very busy, and they're experts in their fields. They wear a lot of hats with their organizations, and they have a lot of responsibilities. So thank you to our presenters today for spending time with us and frankly educating us on a very important issue and the sub-issues associated with them. So with that, I'm going to go ahead and turn it over to Darwincy Clark, the Processing Operations Associate Director here at USCCB and MRS. Darwincy, go ahead.
Thanks so much, Tony, and welcome everyone to the call. We wanted to start the presentation with a bit of context on the CAM Minors program and really what's transpired over the progression of the program itself. So the program was established in 2014 in November, really to focus on the reality that we had a very large influx of individuals coming from the Northern Triangle into the United States.
Next slide, please, Mark. There we go.
Thanks, Mark. And so the aim was to provide a safe and legal as well as an orderly alternative for unaccompanied children. You know, we really focused on the fact that we had a disparity between, you know, our legal immigration system and our ability to allow Central American minor children to come to this country. And so this formalized the process. The question initially was who is eligible, and the program allowed for lawfully present qualifying parents to file for unmarried children under the age of 21. Those individuals were situated obviously in Guatemala, Honduras, and El Salvador. Later, the program was expanded to include additional categories in FY17. And since the inception of the program, we have seen that over 10,000 applications have been submitted, with an approximate arrival number of refugees around 3,700. Next slide, please, Mark. So what are we here to do today? I just wanted to provide some additional fodder for you guys in terms of what our motivation is for this call. We want to first start off with the realities that are in front of us. We know that at this time the program, the CAM Parole program, and the parolee option for individuals which are still in country has been discontinued, and that those individuals which were provided conditional parole will no longer be able to arrive through the CAM Parole option. Additionally, we know now that there is an anticipated sunset of the Central American Minor Program, and that is on the refugee side. We are unsure at this time when that actually will come to pass. We have also heard or been made aware that when this announcement, this program announcement is made, there will most likely be a grace period for those individuals which have applications which the affiliates would like to submit to headquarters and then subsequently to the Resettlement Support Center. We also recognize the fact that we had a lack of support from federal partners. You know, initially we had reached out to the State Department and USCIS requesting for their guidance and assistance on how to support qualifying children, qualifying parents, and their family members which were conditionally paroled in the country of processing. And we realized that we had a disparity regarding the ability for us to support our affiliate offices in working with qualifying parents and the questions that they had. So lastly, the objectives for the webinar, we would like to provide alternative legal avenues for you all to consider in allowing family members to be reunited. We'd like to highlight the re-parole process for CAM kids which are now situated in the U.S. And lastly, we'd like to answer specific questions that you have as you engaged with qualifying parents and qualifying children. With that, I'll turn it back over to you, Tony.
Great. Michelle Mendez with Clinic, are you on the phone? You may need to press *1 to unmute your phone.
Hi, this is Lara from IRAP. She's not on, but I'll cover the section that we're doing together. I can cover that by myself.
Great. Go ahead. Please, Lara, thank you for joining us. And please, go ahead.
Great. So turning to the next slide, just to introduce myself, my name is Lara Finkbeiner. I'm the Deputy Legal Director at IRAP. Just to explain a little bit about what we do as an organization, we provide free legal aid to refugees who are going through resettlement processing. And so we're really experts in that process, especially the U.S. resettlement process. And we help refugees with first instance applications, but also with requests for review, which is what I'm going to be covering today. So just to start out and to provide some context, because I understand a lot of people on the phone have done domestic immigration work and may be familiar with procedure on the domestic level, but may not know about overseas U.S. refugee processing as much. I just want to provide a little bit of background info before we turn to the request for review. The first important thing to know is that what the U.S. does for overseas refugees is that they always contract with an organization, and this varies by region, and that organization actually acts as an intermediary between the U.S. government and the refugee, so that when you're communicating to the government on the refugee's behalf, you're actually talking to what they call a resettlement support center, rather than with USCIS directly. For the Central American Minor Program, this contracted organization is IOM. So any communication on your client's behalf, including submission of the actual request for review, will go to IOM. In terms of the interview process, when refugees enter into the U.S. resettlement pipeline, they have two interviews. The first interview is with the Resettlement Support Center, and that's the time in which they call them RSCs, will organize the case file, gather biodata, make copies of documentation, get a rough outline of the claim. And then the second, much longer interview is actually with a DHS officer that's flown down there, and it's done in person. And this is the interview that becomes the basis for the adjudication. After that interview takes place, people can either get deferred, which just means that their case either needs to go through more initial security checks, or there's an issue with the case, like a complex inadmissibility issue that needs to be reviewed in headquarters. The case could be conditionally approved, which just means that the person needs to go through final security checks and medical checks before they can be approved to travel to the United States. Or the third outcome is that the case could be denied. So moving to the next slide. If a refugee case is denied in the resettlement process, there's really only one recourse, and that's the request for review. And I'll talk a little bit more about that, but just to outline this subsection of the training, I'm going to go over some of the mechanics of request for review, or RFRs. We'll talk about the standard, how to build an RFR, what to put in it, how to support the case, and how important it is to determine the reason for rejection, and especially while you're drafting your RFR, how to address that. So moving to the next slide, just to talk a little bit about mechanics. So as you might notice, a request for review is not actually technically called an appeal. because USCIS maintains that this is actually a discretionary process. Refugees going through U.S. resettlement processing have far fewer legal rights than asylum seekers here in the U.S., including the fact that they're barred from bringing counsel with them to their interviews. And so what they actually call this process rather than an appeal is this request for review. And importantly, this is kind of their one shot. If a case is denied, refugees are not able to appeal up through the courts the way an asylum seeker might be able to in the United States. There is a 90-day deadline marked from when the request for review is sent to the refugee. That deadline is waivable though, and in our experience, they have a pretty forgiving standard for waiving the deadline as long as there are some compelling reasons for waiving it. For example, if the client took a few weeks to find an attorney, if that attorney took some time to screen the case, if they didn't understand the reason for rejection, if the client is a minor and doesn't have a sophisticated understanding of the legal issues. These are all things that you could build into your argument, and you definitely want to include this in your argument if the RFR is being submitted after the 90-day deadline. Importantly, the USCIS guidance says that you cannot file a second RFR if the first RFR is denied. That's true in most instances. We've had some success in getting second RFRs reviewed, particularly if you're able to bring significant new evidence to light. But this is becoming more and more difficult, and our understanding is that the standard is actually being ratcheted up. So this is an important piece of information because if you have a client who is just trying to meet the deadline and they file a very bare bones pro se RFR, it actually might be tougher for you to then submit a second RFR if their first RFR is denied, rather than actually telling them to hold off and then submitting a first RFR and just asking for a waiver of the 90-day deadline. But that's, everything carries its risks, so this is something you'll want to advise and consult with your client on if you're coming up to making a decision on that. So moving to the next slide. In terms of the standard of review for RFRs, RFRs generally fall into one or both of these two categories. One are RFRs in which you are alleging that the reviewing officer made an error in their determination to deny eligibility. The standard is that the error must be significant, which they interpret to mean that it is more likely to not have affected the results, more than likely than not to have affected the results in the refugee case. Secondly, you can also base your RFR on the fact that you're providing new, previously unavailable information or evidence to provide a basis for your client's eligibility. And then the standard for this is whether a preponderance of the evidence indicates that the applicant qualifies for refugee status. When you're developing an RFR, my advice always is if you're able to both allege that an error in determination was made and present previously unavailable information or evidence, that's always in the best interest of your client because it gives you two bases in which you can seek relief. On the next slide, we'll dive a little bit more into allegation of error. This is the first category. This includes, if your client is denied on credibility issues, this includes the failure to fully examine any kind of credibility issue. So if they fail to elicit testimony, if they fail to do sufficient fact-finding, if they fail to compare your client's case to reliable country of origin evidence, that can all be significant error. Another example of significant error is that if you believe your client, let's say is denied on not demonstrating a protected ground in refugee status, but you don't believe that the adjudicating officer relied on the correct case law for their testimony and for the facts of their case, that's another example in which you can allege error. On the next slide, you'll see that we have other thoughts on how to make a case for new evidence. Again, this has to be evidence that was unavailable at the time of the original interview or that came into existence after the denial was issued, you need to include a reasonable explanation about why that information or evidence was not available, and that reasonableness is determined by the reviewing officer. In terms of new evidence, you can really get creative in what you present, and so there's no sort of standard limitation on the form that new evidence can take, and I'll talk a little bit more about that in a few slides. So in terms of the layout of the RFR, these really just look like standard legal briefs. There's an introductory section. You want to lay out the facts of your client's case. You want to talk about the standard of review. Then you want to present your legal argument. It's really important to keep in mind the ground that your client was denied on. So for example, if your client was denied on an inadmissibility issue, let's say they have a past crime, there's no point in building your RFR and building your allegations of error and your new evidence on the fact that they face persecution. Because if they weren't denied on that ground, you can assume that they were deemed to be eligible in terms of that category, because they actually will deny on multiple grounds if they think there are reasons to deny on multiple grounds. So really, really important to make sure that everything, all the evidence and all of your legal arguments are making a case specifically on the denial ground in which your client was dinged. Finally, you want to include a conclusion and, of course, a list of enclosures. IRAP has developed what we consider to be a good template for formatting of an RFR, which we're distributing in connection with this webinar, and which you can feel free to use or distribute to your clients if they'd like to pursue this claim pro se. Moving to the next slide. In terms of the substance of an RFR, one great thing about overseas refugee processing is that we're not beholden to any particular jurisdiction in the U.S. You can actually pick the case law that's most favorable to you regardless of which circuit it comes from, because all of the circuits basically apply the same in overseas refugee processing. So on the next slide, just to talk through a little bit more about determining the reason for a rejection. This is a really, really important thing to focus on and think about even before you start drafting an RFR. Refugees, when they're denied, are issued a 2-page form called a Notice of Ineligibility. This is a very standard form, and the only information the refugee gets is basically a checked box. So for example, it might say you were denied because you failed to establish you had a well-founded fear, or because you are deemed not credible with regard to your admissibility to the United States. That's the only information that they get. It's still really important to get this notice, because without the notice, you really don't have anything to build the RFR around. Again, this RFR is not about building an entire case for your client, but it's really about attacking the specific denial ground. Once you have that notice, there are still tools you can use in order to kind of further flesh out why specifically your client was denied. For example, we always try and interview our clients or our potential clients really carefully to see what went on in the interview, what questions were asked. Did the interviewer focus in on anything and ask repeated questions? Those might be clues as to kind of where the interview went wrong and what they deem to be the legal issue with your client's case. If they submitted anything in written form to USCIS, you'll want to ask for a copy of that as well. Another tool that you have at your disposal in order to get more specific information on the denial is you can actually make a FOIA request for the refugee's file. So that request should go to DOF and to DHS. It should be 2 separate requests. In the file, sometimes you'll get some of the forms that are filled out on the refugee's behalf. If you're lucky, you might even get interview notes taken by the officer that was doing the adjudication, although sometimes those are redacted or left out. One thing to note about these FOIA requests is that although it's only supposed to take 20 days for a response, many times we see FOIA requests take months and months before they come back with the file. And so we recommend that you file the FOIA request and perhaps drop a footnote in your RFR stating that you filed one and you reserve the right to amend. an RFR if it comes back while your RFR is pending, but I would not wait for the FOIA to come in order to submit an RFR. In terms of evidence collection, this is a really, really important element in drafting an RFR, particularly if it's a second RFR, because if you don't have any new evidence, they're absolutely not going to review it. So it's really important that you get specific and consistent documentation to corroborate your client's testimony and to specifically address the denial ground. Things that count as new evidence include affidavits from the client, affidavits from family members or experts or anyone with direct knowledge of your client's case. Corroborating evidence could also be death certificates, medical records, photos, threat letters, text messages, emails, etc. And then, of course, country conditions information. One really important thing to know about the request for review RFR process is that because all of this information is submitted primarily electronically, what you're not doing is building a huge brick of papers that you want to submit like you would do attach it, because that actually might make your actual email attachment too big. So any kind of attached evidence should be incredibly specific to your client's case. For example, if your client's case really focuses on a particular client's testimony. That's if this policy varies at all in their as an attorney, if you're submitting the RFR, you want to make sure to attach a signed D-28. And then in terms of possible outcomes, an RFR can either be denied. They might grant a re-interview if they think that the RFR presents new information that needs to be further explored by an interclient. Conditional approval, which just means that your client is approved pending final security and medical checks. So just to sum up, I just want to say that if anyone is looking to refer cases, Kind and IRAP are actually partnering on a project right now to try and take on approximately 100 RFRs. And so if you'd like to refer a case to us for consideration, the next slide has links to Podio forms that you can fill out with information. There's a longer form which we're using for more advocacy purposes, and then a shorter form to refer cases if you'd like to refer them to us, and we can look at them. Of course, a referral doesn't guarantee representation, so if your client hasn't heard from us within 1 month of the deadline, please go ahead and invite them to file or assist them with filing. So with that, I'm happy to answer questions now.
Laura?
If anyone.
Laura?
Yes.
Hey, sorry to interrupt. It's Lisa. I'm just seeing several people say that they lost the audio, and they lost it around the start of evidence collection, and some of them are now calling in instead. And I just wonder, people asked if you could either pause for a minute, and some asked if you could maybe just repeat starting from evidence collection because they missed.
Sure, sure.
Okay, thanks.
Is everyone that needed to? They've all called in?
Yeah, it looks like okay. Yeah, it looks like people say that the audio is back, and they've called in using the telephone. So yeah, if you don't mind, Laura, please.
Yeah. Sorry about that, everyone. So in terms of evidence collection, I was just saying this is a really critical element in building a successful RFR, particularly if this is a second RFR, because they really won't consider second RFRs unless there is very compelling, previously unavailable new evidence. So what that can constitute is affidavit from your client, additional affidavits from family members, experts, anyone with direct knowledge of your client's situation or case. Corroborating evidence can include death certificates, medical records, photos, threat letters, text messages, emails, etc. You can really get creative in the kind of evidence that you can attach. Country conditions information can be an important resource as well. One thing that I think is important to know, which is very different from asylum proceedings here in the U.S., is that a lot of the RFR submissions are done electronically, which means there are actually email server limits in terms of size. And so it's important that you keep that in mind when you're deciding what to just cite to in your legal argument versus what you should attach. And so the example I gave is if it's a general human rights report from Human Rights Watch talking about conditions in El Salvador, that's more appropriate to footnote as a citation and perhaps quote from it in your legal submission, versus something like if there's a local newspaper that is covering a very specific attack that is central to your client's case and to their story, you might want to actually PDF that and attach that to your RFR. And then the last thing I just want to talk about is that the Center for Gender and Refugee Studies has a great online resource in which you can fill out a form and talk about the specific facts of your client's case. And they will email you back with curated resources on country conditions and recommendations for expert declarations. And that can be a really helpful tool when you're building your client's submission. Should I go ahead and answer some of these questions, or should I talk about submission? I'm not sure if people heard that or not.
Yeah, let's go into these questions, and then folks, if you want Lara to go over the submission, type it in the chat box here, and we'll see where that's going. There's a couple of questions here. First one is from Jackie Ramos. I'm new at this. Can you explain what is meant by sunsets?
Yeah, I can take that, Tony. So when I mentioned sunset, I wanted to be specific in regards to the fact that what we have been told is that when the CAM program does end and it is announced via program announcement, there will be a grace period or a sunset period between the time when that announcement is made and the time in which DOS PRM stops taking applications.
Thanks, Darwency. And then, Laura, this is directed to you. It's from Lisa. If you argue favorable circuit law, must USCIS consider it, or can they consider decisions out of less favorable circuits?
Yeah, so technically they sort of have the same ability as you to look at, all circuits are equally persuasive to them, so they technically can consider less favorable circuits. I think the nice thing is that you're the one that's presenting the argument in this RFR. So because of that, you can build your case and you can cite to X number of decisions, and it's really on them to have to go up and look at other other decisions out of other circuits and determine what side of the line they think that the case law falls on the whole. But yes, they can technically look at other circuits as well.
Okay. This question is from Eduardo. Does the RFR should the RFR be submitted overseas, meaning consulates, embassies, not in the USA? Yes.
So this is something that Lisa and I are still clarifying, but my understanding is that it's going to be submitted directly to IOM, which is the Contracted Resettlement Support Center, the intermediary here. We're trying to figure out whether or not it's okay to email the RFR or if it needs to be presented in person at the office. But we can follow up from this webinar and provide clear instructions on how to submit. I saw there was a question also about the email servers and what the limit is. This tends to vary by it varies by Resettlement Support Center what their email service limit is. That's also something we can follow up on with IOM in the CAM context and let you guys know. It's something definitely to keep an eye on, because what I've seen before is when people submit RFRs, they just don't get, usually you'll get like an automatic kind of acknowledgement of your email. If you don't get that, it probably means that your email size was too big, that the attachment was too big. And it's really a shame because, you know, they haven't received it and you think you submitted it. So we'll definitely follow up on that and let you know.
Okay, a request and a question. First, the request. Can you provide a template to request a waiver of the 90-day deadline?
Yeah, I'll tell you what, we have a primer that we've written on request for review where we include common arguments to raise. It's a really fact-specific argument, so I don't know if I can provide a template necessarily, but what I can do is send out the language and the suggestions that we have in terms of past arguments that have been compelling and asking for a waiver. Okay,
and then last question before, you know, there's a few other ones, but let's take this one, and then, you know, we'll let you continue before we take some more. What is the exact size limitations for the RFR?
Yeah, so there's no, I guess the only size limitations really are, like the firm size limitations are if you're submitting this by email, and that's just based on the Resettlement Support Center's email servers, and like I said, that varies. If it's being submitted in person or through the post, there's no firm size limits, although we have heard that they prefer smaller submissions, and this is kind of going in line with what I mentioned before and how this is pretty distinct from the asylum process here. You really want the RFR to be specifically focused on the denial grounds and for any attached evidence to be really critical, specific pieces that go to support your claims, rather than you know, that brick of papers that are usually submitted in a domestic asylum proceeding. So again, there's no size limit. Normally I would say for written arguments, our RFRs tend to be between 5 to 15 pages. It really depends on what the denial ground or grounds are. And then, you know, with attachments, you know, that can vary as well.
Thanks, Laura. It looks like we went through a number of these, and you know, we have some more queuing up. So, you know, if you want to continue, go ahead, or we can take some more questions. I'll leave it up to you.
I'm happy to continue taking questions.
Okay. Okay. Let's see. Is there a parallel resource to the Gender and Refugee Studies Country Condition resource regarding relevant and useful case law for these RFRs?
Yeah, actually, the Center for Gender and Refugee Studies also has that available as well on their website. So they can point you to helpful case law based on the facts of your client's case as well. So in addition to the country conditions, they also have the case law side.
Okay. These are related from a couple of people. Some of our clients are told that you should just write a letter in English, you know, in meetings with IOM. Is that something that you would advise, or is that something that people should just disregard?
So if your client does write a letter in English and signs it and submits it, that will be considered their RFR. That's an important thing to know because, as I mentioned before, it's much harder to get a second RFR reviewed rather than you know, either trying to help them now before the deadline or even getting the 90-day deadline waived. So that's an important piece of information. The thing that we see with pro se RFRs is that a lot of times, obviously, you know, most people are not legally trained, may not be even fluent in English. And so, you know, as a last resort, if you're not able to help people, if you're not able to refer them on, obviously it's better for them to try to get their case reviewed by submitting something. But if it's possible to first screen their cases and at least provide them some kind of advice, if you can't, you know, take on the representation yourself, that would be my advice, because that will be considered to be their RFR.
Wow. So Cass Cogswell is asking, why are they being told this, you know, to submit a letter in English? I don't know if you know.
Yeah, my guess is they're just being informed about the RFR process because it does have to be in English. They may not, remember this technical terminology, or they may not even use this technical terminology. But my guess is they're just being advised and saying, they're being. Oh, this is an important point, by the way. I should have said this before. My understanding for the CAM program, based on language on the USCIS website, is that when the minors are being called in and given their parole revocation notice in person, that is the date in which the 90-day deadline starts from there. And so my guess is they're being given this notice, and they're explaining to them, you can now try and appeal your refugee claim, which would need to be something written in English and submitted explaining your case. It would be best, obviously, if they could advise them and let them know that they can seek counsel in those proceedings. But that's my guess, is they're just kind of trying to flag the fact that the RFR process now exists, is an option for them.
Okay. Barbara is asking, how do our clients get a copy of the notice of ineligibility?
Mm-hmm. Yeah, so if they should have gotten it back in 2016 or whenever they were interviewed, but if they never got it or they don't have it anymore, it's their right, obviously, to get the notice. So that they should contact IOM by phone, by email, or go in person and ask for their notice of ineligibility.
I'm glad, Lara, that you are on this webinar today, because I wouldn't even begin to know how to answer some of these questions. So these are very technical, and you have the expertise. So I'm grateful that you're on. We have a few more questions, and we have, it looks like, a couple of other people typing in some questions here. From Cicely, that's her name. Does the new evidence have to relate to circumstances at the time of the original decision denying refugee status, or can the RFR be based on new/dangerous circumstances occurring after the denial?
You'll want to do both. You can definitely bring up new changed circumstances, and that would constitute new information or new evidence, and obviously there's a reasonable explanation for why that wasn't included in the first part. But I still think it's in your best interest to address the original denial and just, still allege that either significant error was made in denying eligibility, and/or this would go to the new information category. But as I said before, I think in building these RFRs, you want to provide as many bases for relief as possible.
Okay. Someone is asking if they can get or where they can find the physical mailing address or an email address for sending RFRs.
Yeah, we will send that out to participants after the call. That's something that Lisa and I are obtaining clarity on.
Okay. I don't know if you can answer this one.
Hey there, hi, sorry to interrupt again. It's Lisa. I was just on mute. And there is a physical mailing address in El Salvador to submit to IOM, which IOM El Salvador has really been leading the RSC kind of work on this. And there is a physical mailing address. I have email addresses for the different IOMs, but but that's what we have to determine, is if there is a separate email address for the RFR. So we can just follow up and send all of it together, but there is a physical mailing address in El Salvador. And the other question is whether USCIS, the United States, will accept these directly via email. So we will follow up, like Lara said. But we do have the hard address, I just wanted to say, for now.
Great. Let's see here. There's a question from Kelly. Is it legal to charge for an RFR, or must it be pro bono, since the CAM application is free by law?
I don't think it's illegal to charge for an RFR. It would be like any proceeding in the U.S. in domestic context in which the actual program is free to apply to. But there are attorneys that choose to charge for representation.
Great. And then from Kaz Cogswell, the review of our RFR is discretionary. In your experience, are RFRs typically reviewed? Yeah,
that's a great question. Yes, I mean, it's a long-standing practice that they review every RFR, even during the refugee processing suspension, we received word that they would continue to review RFRs. So this is a long-standing practice, and we've never seen them fail to adjudicate a first RFR just because it's technically a discretionary process that was created by USCIS.
Okay. Another one here. I've been requesting copies of notices of ineligibility through USCIS. Do you think that is going to take longer than the QP requesting it directly from IOM?
Yes, I do think it would take longer. Although the QP, the qualifying parent, that's a qualified parent. Yeah, I think that going to IOM, either the qualifying parent or the minor going to IOM directly to request the notice of ineligibility should only take as long as it takes them to respond to an email. It's possible that if you go through USCIS, that it might be a longer process, and they'll give you a little more of the runaround since you're an attorney contacting them.
What happens if or when the CAM program is canceled? Will the review continue? That's
obviously hard to say, you know, because there are a lot of extraordinary things happening to immigration programs. But in my experience with the end of similar overseas programs is that they will allow people who applied and who are somewhere in the process to finish the process, essentially, even after the sunset of the program, meaning that they're not taking new applications. But I can't make predictions. I definitely think it's in everyone's best interest to really focus resources on helping people, as many people as possible, file these requests for review. But, you know, it's hard to say.
And then a related question, but if TPS is also canceled, then what happens?
So people, I guess I should explain this. If people are granted through this program and are allowed to resettle, I don't know if this is a hypothetical building on the first hypothetical, but I'll just say that if people are are approved to this program, their RFR is approved, they'll come here with the status of a refugee, which means they're not here with TPS, they're not here as a parolee, they're here with the same status essentially as an asylee. They get resettlement benefits, and then in a year they can actually apply for adjustment.
For folks on the phone, on the webinar, great questions, and thank you, Lara, for taking them all. Let me see here. Lisa,
and I'll just say, I have other resources I'm happy to distribute, including I saw questions about like redacted, successful past RFRs. We can send those out. We can send out information for how to do FOIA requests. We're happy to send out those materials as well.
Okay. Yeah, and I'd be remiss if I didn't say that these resources that Lara and Lisa are going to send folks on the webinar, we'll have them posted on the justiceforimmigrants.org webinar page along with this webinar, the recording of the audio as well as the slides. You know, Lisa, you're on the phone as well, and you're just as much of an expert on this. Is there anything you wanted to add or anything you wanted to cover while we have the chance to have you on the phone?
Yeah, I've got a series of slides that are coming up right after this.
Okay.
But let's see if Lara, if there's anything else that you were covering before we go to this next slide.
Nope, I really think that's it. But if you do want to refer cases to us for consideration, please go ahead and fill out those forms and we'll take a look at them. And you can always contact me if you have questions on the RFR process or if you have questions on a referred case. I'm happy to chat.
Katie Picker just made a great point in the chat before I start doing my slides, which she asked me to read this out, and she's totally right that parents of qualifying children who are approved as refugees through CAM could file I-730s for their spouses here at TPS. Wait a minute. Parents of qualifying children, yes, if the parents are approved as refugees, exactly, and come over here, then they could file I-730s for the spouse that has TPS. That's a really important point. So, okay, so if you could advance the slides, that would be great. Great. So I'm going to talk about two things. I'm going to talk about both sort of common fact patterns that we saw. So KIND worked on a very small number of CAM cases, working with some civil society organizations in El Salvador and Honduras to support some children going through the process, and learned a lot through that. And also we have obviously many asylum cases, or not obviously, we have many asylum cases in the U.S. where we represent unaccompanied children. And so based on those kind of two sources of information, I want to spend a few minutes talking about sort of common fact patterns, which will be really relevant to the potential bases for refugee status, as well as some pitfalls, shortfalls, problems that we heard about or that could be happening, could have happened in the refugee interviews that may in part explain the denial. And then the second thing I wanted to spend a little bit more time on talking about is individuals who entered the U.S. on parole under CAM, those who got here before the cancellation of the parole part of the program, and what to do for them, what the options are for them. So first, we see, obviously there's more patterns than I put on this particular slide, but we tend to see very frequently cases fall into three sort of different broad patterns, and one is gender-based violence, another is family-based violence cases, and then the third is gang, kind of violence that's not family or gender-based, other kind of gang violence. So gender-based violence cases, intimate partner violence cases, we see a number of cases out of Central America involving girls who are forced to be the girlfriends of gang members, pressure to be the girlfriends of gang members, forced into domestic relationships, and then also cases involving violence, threats, hate against LGBT individuals, whether by family members, community members, gang members, et cetera. And those kinds of cases all have good potential, good case law to support, arguments for them. We also have seen and do see a number of cases involving family-based violence, so either violence within the home, child abuse, incest, which also may well have a gender-based, in many cases will have a gender-based angle, but child abuse, incest, other violence in the home, and then cases involving violence directed at kind of an entire family. So one family member resists the gang, and then, the entire family is targeted as a result of that. So we see that, pretty frequently. And then we also have seen a number of cases involving gang violence, sometimes because of religion. So, for example, a child in evangelical family that is proselytizing and trying to recruit youth into the church and away from, and even recruit some gang members away from the gang into the church, and being targeted as a result of, potentially being viewed as competing with the gang for youth. So cases based on religion, individuals targeted by gangs because it could be a benefit to the gang because of their professional skills or profession. So medical, background, nurses, medics, potentially doctors, and students who are targeted for a host of reasons, and schools, a number of schools in Central America where individuals have had to leave school because of gangs either having a very strong presence at the school or targeting them on their way to school or home from school. So these are just some fact patterns I wanted to mention because, of course, if the denial, let's say, wasn't based on, Lara gave the example of having committed a crime, and if that's the reason for the denial, that obviously isn't about meeting the refugee definition. That's about inadmissibility issues. So when the denial is actually based on not meeting the refugee definition, it's obviously going to be really important to be thinking about the ways in which the person can fulfill the refugee definition. So I just wanted to point these out. Next slide, please. In terms of thinking around some of the problems that happen in interviews, from children and families we talk to involved in the CAM program, in some cases we believe that interviews may have been pretty short and that the officer really didn't take the time to develop the facts of the case, and that is certainly challengeable as an error. And the child maybe didn't really have a chance to talk about what they had been through or get asked the kinds of questions that would allow them to do that. some children feeling really intimidated by the refugee officer, maybe because they were asking questions aggressively. In some cases, there was a sense that they were being accused by a refugee officer of being gang members, and the officer may have been really kind of fixated on that, and therefore that's where the interview got stuck or focused, and that may have been the reason for denial, or it may have shut a child down from talking about what they'd experienced. Some children who potentially didn't understand questions that they were asked or didn't understand the interpreter and so didn't have a fair interview. And in some cases we heard that, we know of one case where the persecutor knew about this process happening and threatened a young woman before she went into the interview that he was going to harm her if she said a word about what she was experiencing, about the domestic violence she was experiencing. There can be other cases like that as well, where that would have shut down the child or the individual from talking about what they had been through. So I just wanted to kind of mention those, potentials. And then I'll shift to individuals in the U.S. with parole status that entered through Camp Parole. If you can advance, please. Okay, so there's about 1,500 individuals who entered the U.S. on parole under CAM, and thus far, and this is actually even on the USCIS website, so thus far, the administration is saying that they're going to allow people to remain in that parole status until it expires, that they're not going to revoke it like they did for those conditionally approved. That could change, but as of now, that's the case. But of course, the big question is what's going to happen once parole is expiring or runs out, and it's a huge concern because this administration has, made everyone sort of a target for or priority for deportation. And so if people are in the U.S. and parole, they're no longer in valid parole status and they're not in other status, and obviously DHS has their contact information and ICE has their contact information if they haven't moved, they could be at risk. And we think it's really, really important. This is the kind of, big takeaway. It's really, really important for people to, in that situation, to get assessed, get a legal screening, meet with a lawyer, see if there's any other type of relief that they can qualify for. Maybe they do actually have a good case for asylum, even though they were denied refugee status. Maybe there's some other avenue of eligibility that they have now that they're in the U.S. Who knows if they've married a U.S. citizen? Who knows if some people may have been victims of crime since they've entered the U.S. and could be eligible for U visas. There could be different bases, but it's really important for them to find out. In addition, if you could advance, please, folks are going to be able to file applications for re-parole. Now, I don't know. I have a lot of questions around how this administration, how USCIS is going to handle these requests, given that the administration has very, very strongly signaled it's going to narrow parole significantly. It's planning to, that the Obama administration was overly generous in granting it, and parole is supposed to be in very exceptional circumstances. So we don't know, but these folks who are here in parole are eligible to file for re-parole and obviously should really seriously consider it so that they don't end up in a situation where they're out of status. So first I'm going to talk briefly on how to do it and then on what the standard is. So briefly on how to do it, there's not actually an application for re-parole. There's no such thing as an application for re-parole, so it's a little bit funky. They have to actually file an application for a travel document as if they are either in the United States planning to leave the United States and seek permission to re-enter, or as if they are outside the United States seeking humanitarian parole, when in fact we know they're inside the United States and they're not seeking to travel. But they have to use Form I-131, which is called an application for travel document. And I wanted to explain that because it doesn't look like the right application. And also when you go to Part 2 of that application and you see the different descriptions, I am in this or that situation and that's why I'm filing this application, none of the boxes say I am in the United States and seeking re-parole. So actually the person has to check either box 1E or F, which says that they're either outside the United States applying for advanced parole, or that they are someone in the United States applying for someone outside the United States. So it's a little bit funky, and they need to therefore write re-parole across the top of the application to make clear that that's what this is. We recommend that people file at least 90 days before their parole expires. Obviously, if someone's already Beyond that, they should still, that doesn't mean they shouldn't go ahead and file because they're already on the radar screen and they might as well see if they're able to succeed with this. But there is a filing fee of $575. I've included the hard addresses of where to file, and it depends whether applications are sent via regular mail or via express mail delivery service. Next slide, please. The standard, I'm going to talk about the general standard and then I'll talk about certain elements of it in just a minute. So the general standard is that the individual has to establish that either, and this is the parole standard, there's not a separate re-parole standard, just to be clear, but that for humanitarian parole, either that there are urgent humanitarian reasons, in this case for them to remain rather than enter, to remain in the United States, or that it would be a significant benefit to the United States for them to remain. So either or, obviously they could try to establish both. And in addition to that, they have to show that they warrant a positive exercise of discretion to be granted humanitarian parole, to be granted, re-parole, to essentially remain. And in general, parole requires as much evidence as possible, and in this case, I think is really going to require a lot of evidence under this administration. Next slide, please. So the standard for urgent humanitarian reasons, the idea is to show that the individual would suffer grave harm, essentially, if they were not granted parole, and kind of what is that harm, what's the nature of that harm, how urgent or emergent or severe is it? These are all questions. Who does it affect? Does it affect just them? Does it affect others in the United States? And the idea of humanitarian parole is that it's supposed to be, typically it was put in place and is often used for kind of urgent medical reasons. So someone seeking to come to the U.S. to have an operation they can't have in their country, et cetera. Or to come care for a very, very sick or dying family member, to attend a funeral. So obviously it wasn't, it wasn't created for these types of situations. That said, there have been cases of individuals who've gotten humanitarian parole because, let's say, they had their parent had a pending application for them, either family-based or an I-730, and meanwhile they're in extreme danger in their country and they can't remain safely. Or, we knew of a group of girls who had been kidnapped by girls who escaped from Boko Haram, who used humanitarian parole as a way to get to the United States to seek asylum. That is extremely rare, and the U.S. doesn't typically grant that kind of humanitarian parole because there isn't an asylum visa, and humanitarian parole isn't in theory meant to bring people here to seek asylum, but it has been used in some of those situations, and it has been approved in some of those situations. Also, if there's, sometimes the family reunification in and of itself is unfortunately not enough of a reason for humanitarian parole, but if there are additional circumstances like a very young child or a sick child or a child with significant special needs, with developmental delays who needs some kind of special care or doesn't have a family member to care for them in their country, then that, combined with family reunification may make a difference. I think in these CAM situations, because of what we're seeing from this administration, if I were doing one of these, I would frankly want to throw the kitchen sink at it. I would want to argue every kind of family reunification related, reason, any kind of special circumstance, and the country conditions piece. So really that it's unsafe for the child to go back. Obviously, to the extent that there's individual circumstances that show it's unsafe, they were threatened in the past, family is threatened. Now that would be helpful, but even if there isn't, using the general kind of country conditions in Honduras, El Salvador, and Guatemala to justify the country danger. But then in addition, to argue, this is a child, and it's not just family reunification. In this case, they actually had been separated for many years, reunified with family, and now they're facing being torn apart from that family, and that might have really significant mental health and other effects on them. And then again, of course, the younger the child, and if there are other, circumstances. It's also really of interest, to the U.S. in cases, I know it's a lower number of cases, but if the qualifying parent is a permanent resident. That's something really worth arguing, that it would affect a permanent resident. If they were not granted re-parole, it would harm the permanent resident. And if there are family members who are citizens, so it wouldn't be the qualifying parent, but if there are grandparents or others who are citizens that would be affected that are in the U.S., and that, of course, would be worth arguing as well. Next slide, please. And then the significant public benefit standard is probably going to be less common in these cases, but it may apply in some cases. So is there some way in which this person's time in the United States could really be of benefit to the greater good, to the greater community, to the United States as a whole, to their particular community, to their state, and so looking at things like, let's say there was a crime that they witnessed and they're a testifying witness or helping in the investigation in some way, that could be undermined if they had to leave the United States. If they're participating in some kind of medical clinical trial and the results would benefit the greater good, maybe if they're some kind of really talented, artist and is contributing to their community, I think it would really, it's going to be case by case, obviously. But to the extent that there's any good argument on that, I would add it in addition to the humanitarian reasons, because, again, I think kitchen sink is going to be key here. Next slide, please. And in addition to urgent humanitarian reasons or significant public benefit, the question is whether they merit a favorable exercise of discretion. So anything generally about, their kind of positive character, good nature character, that, letter from a pastor, from a teacher, from a community leader about them and their contributions, and their character. In addition, again, like I said, relationships with relatives who may be permanent residents or citizens. To the extent, so parole is, here's one of the catches, it's supposed to be temporary in nature. And so to the extent that this looks like this person is going to keep seeking parole and has no other option, that I think will be considered negatively in this application. So to the extent, and this relates to what I said before, that they might qualify for some other form of immigration relief, U visa, family-based adjustment. Some people got parole, but they have a parent who's a permanent resident who can file for them, even if it wasn't. I know of one case where the qualifying parent was the parent who had TPS, but there is another parent in the United States who has permanent residency, and they weren't the one who filed. So they could file a family-based petition, maybe there's an asylum application. So to the extent that you can show that they have or are planning to file an application for a form of relief that would make the nature of parole ultimately temporary, because they're not going to keep seeking to renew it, that would obviously be helpful, I think, to their argument in their case as well. Negative factors here would be criminal history, fraud, national security concerns. And then one more to mention is, the concern, to the extent that you can show that this person would not be a financial burden, which is, I think, helpful in many of these cases, the fact that they have a parent who's lived in the United States for years and likely been working in authorized status for years, there is a source of support and income, and maybe they themselves have jobs, and some of them certainly do have jobs. And this is kind of a balancing test. So I'll stop here because we haven't done any of these. I mean, KIND is not doing these. We're not a resettlement agency, and we haven't been. And we work with unaccompanied children in the U.S. So we haven't done any of these requests for re-parole under CAN. So I can't say how any of them have been decided. But I'll stop here in case there's any questions I can't answer.
So, Lisa, there are two kind of related questions here. The first one is, how long does the initial parole status last? And then the second one is there any reason you would not seek re-parole concurrently with an asylum application for clients in parole status?
Got it. Okay. So I'll address the first one first, the concurrent nature. I mean, I actually think it's helpful to the parole application to the extent you can say, the individual has a pending asylum application or is planning to seek asylum. I think it is helpful. I mean, the idea is that they are hoping asylum can take, quite a long time. If they're able to file for asylum while they're in lawful status, let's say they get a grant of parole, a renewed grant of parole for a year, for example. To to the extent that their asylum application, I mean, there's huge backlogs, so this is not particularly likely that the decision would be made within the year. But let's just say if they're in legal status at the time they have their asylum interview in the U.S., if they're not granted asylum, they will not be put in removal proceedings. They just won't be granted asylum. They'll revert back to their parole status, and when it expires if they don't get a renewal. So it's definitely preferable to be in status at the time of their asylum interview. So I would file concurrently. For those cases where it makes sense to file an asylum application or some other application. And the other question, initial parole. So for CAN, initial parole was supposed to last up to 2 years, but the actual, parole gets granted at the airport by CBP. And the I-94 stamp sets how long, what the CBP officer approves. That's what the parole is, and I understand some people were given 2-year parole and some people were given 1. And my sense is that more may have been given 1-year parole, but I don't know for sure.
Great. Lisa, can you speak about the historic percentage of reversed RFR decisions and provide your thoughts on why these reversals have been so low historically?
I'm going to defer to Laura on that, assuming she's still on.
So this is a question on the historically no numbers for RFR approvals?
Yes.
Yeah, I mean, I would say the vast majority of RFRs are filed pro se would be my initial answer. To my knowledge, we're the only organization that focus primarily on doing that type of work, and obviously we don't cover every refugee in the world. So I think if not done pro se, then there's not a lot of organizations that have specialty in doing these RFRs, so I think that's another factor. So I think that the assistance of an attorney in building a record and building a case around this can be incredibly meaningful in this process.
Here's a question from Carmen in New York. If a person did not have an asylum claim when they first entered, but now they have that fear, can they file a CAT application specifically due to the increased violence with so many deportees?
This is Lisa. I'll take that. So the question is really related to the 1-year filing deadline, and so somebody entered the U.S. It's a year later. They didn't file for asylum within a year. The deadline can be. There are arguments to the deadline not applying, and the deadline doesn't apply. It doesn't start to. It's not that the deadline doesn't apply. When does it start ticking is the question. It doesn't start ticking while somebody is. One can make a very good argument, and there's the regulations address this. Federal regulations, that it doesn't start ticking while somebody is in lawful status. So during the time that person was on parole, the deadline, in theory, wouldn't have started ticking. So they actually aren't barred from filing for asylum.
Great. Let's see here. So here's one that we missed. Who represents or answers questions for young minors at their interviews?
I can take this one. This has been one of the issues. The children are interviewed themselves, but in these interviews, in many of these interviews, and it really depends on who the officer was, the caregiver in the country of origin was in the interview, and this is actually, I didn't put this on my slide. This may be something to ask about too, because if it was a situation involving violence in the family, that young child may not have, or any child may not have disclosed it if the caregiver was in the room, right? I mean, that's very complicated. But anyhow, in cases of younger children, definitely the caregivers were in the interviews. In cases of older children, it depended on the officer whether they had caregivers in the interview, but I believe they were in the majority of interviews. And again, that may well have affected what the children disclosed. But they were not entitled to have counsel in the interviews, and so nobody actually represented them. But anyhow, so. Okay.
Xavier has a suggestion for the resources that you're all going to send. If that could include guidance on what happens during new interviews after the RFR goes through, that's what he's looking for. So that's an FYI, Lisa and Laura.
Yeah, absolutely. Our primer section on RFRs covers what re-interviews look like, so I can send that entire chapter.
Okay. Kelly has a question here. Excuse me. Humanitarian status guidelines talk about proving the temporary nature of the need of the status. How do you address this?
Yeah, that's what I was saying before. I mean, I think that it's really hard in cases where somebody is not filing for another form of relief. You know, to be able to say, I need this to protect me essentially and be here while I'm meanwhile seeking another form of relief. I don't know the best answer in terms of cases where there is not another form of relief, except that to say perhaps, you know, the country conditions piece is like the conditions are so grave right now, hopefully they will improve kind of thing. You know, and so right now it is totally unsafe for me to return to my country, and right now I'm 15 and need to be with my parents. To just maybe focus on the real present need and perhaps something around, you know, the nature of conditions might improve.
Here's a
not great, but yeah.
Question from Mary Reedy. And I'm going to just read this. Am I correct to understand that of the 10,000 applications, only 3,700 have been resettled as refugees and 1,500 granted parole status? Does that mean that about half of the applicants have been denied, or just half the applications have not been reviewed at this point?
So the numbers are actually a little bit different than that. So there are now, on behalf of individuals, applications have been filed on behalf of over 13,000 individuals, according to PRM. I don't have the exact number, but this is as of, you know, a couple weeks ago. And about 1,500 entered on parole. About 1,600 entered on refugee status. There's another 500 that had been approved for refugee status that are somewhere in the kind of travel line to get here. And then that leaves however many that have not yet been given a decision. It's around 6,000, 7,000, if you do the math. You know, so 3,000, there's around, there's a number, many, 7,000, maybe closer to 10,000 actually, that are somewhere in the pipeline that haven't been decided yet. Many have been interviewed, and haven't yet received a decision. In fact, we know of some cases where the interview was over a year ago and they haven't received a decision. Others haven't been interviewed yet. But out of those that were interviewed and a decision was given, we understand that around 30% of cases have been approved for refugee status and close to 70% on parole.
Okay.
Tony, yeah. This is Darwin. Just to add a point there, you know, we have been in direct conversation with PRM, and you know, we receive semi-regular updates on the total number of refugees departed. Unfortunately, the latest number that I have is from April, and in April, PRM was stating that 2,745 individuals had been departed as refugees.
Oh, really?
Yeah.
Huh.
Okay. Here's a question. What is the IRAP RFR approval rate? An estimate of the approval rate when the client has representation.
That's a great question. I'd have to pull that. It's varied by year. I would guess it's between a third to 50%, and that's like gone up and down a lot by year.
Okay, here's another question from Eduardo. Should we contact the QCHs / families to ask them about the interviews, or should the lawyers do it?
I mean, this is Lisa. I don't know, Laura, if you would say anything different. I mean, I think it depends whether there's a lawyer in the case. So if somebody has hired a lawyer, then the lawyer should go ahead and do that. And if somebody has not hired a lawyer and wants assistance, you know, and your affiliate, you know, is willing to help, you are helping, then I definitely would. You know, I would either ask the parent to ask the child. I mean, you might want to go through the parent, right? I mean, I would strongly suggest going through the parent. Either ask the parent to find out, ask the parent to see if you can talk to the child and at least inform the child that you're going to call, because one of the things that we've experienced, and to give a sense of when you're going to call, is that, because gangs get access to people's cell phone numbers and call, unrecognized numbers sometimes make people think that it's a call from a gang, and either they won't answer, and they might be afraid. So you want to obviously avoid creating that kind of situation. So to the extent you can communicate and coordinate with a parent around when you're going to call, what your phone number is, that kind of stuff, then that is helpful.
For folks on the webinar, I've typed it out here in the chat box, excuse me, and a number of you have asked your questions in the chat box, but I'm just going to add it and mention it now. If you have more questions for Lisa or Lara or Darwency, please just go ahead and type them in the chat box here. We have about another 10, 15 minutes on this webinar, and we do want to give you an opportunity to ask your questions. So go ahead and ask them there. And it looks like we do have some folks typing now. So Carmen, again from New York, has a question. How can we advocate for the continuation of the Central American Migrants Refugee Program?
Well, I think that local, reaching out to local congressional representatives from, and when I say local, I mean state and district. So House representatives and senators, but really in this scenario, from what we've seen with this administration, to the extent that Republicans can come on board and vocally, express their commitment to this program continuing. And at a minimum, one of the things that I think would be really helpful is a commitment of a statement from Republican congresspeople around, at a minimum, processing the cases that are in the pipeline. We've heard that that is supposed to happen with the sunset, but haven't seen any written commitment. So to prevent that from changing, some kind of real delayed pressure on the administration around that, would be helpful. So support from congresspeople, and in particular Republicans.
I wrote that down for my information as well, Lisa. Thank you. Okay, here's a question from Philippe. What is the best way to follow up on CAM applications that are pending?
I can take that one. So essentially the applications that you filed at your affiliates, the way in which, we engage in this process is that you should communicate with your headquarters, your National Resettlement Agency, and they can provide you with updates on the status of your CAM application that is in process.
Here's a really good question from Sarah Cumberland. She says that she's been struggling to find attorneys willing to work with an I-131 for re-parole, even for a fee. Do any of you have recommendations on how to locate, an attorney or these resources?
Geez, I hadn't heard that. I think it really depends. Probably this is going to vary by area, but to the extent that you have bar associations locally that have pro bono networks, that might be one possibility. Law school clinics might be another possibility. I'm surprised that people for a fee are resisting doing these. So I don't know, those are some thoughts I have offhand. I don't know, Laura, if you have more.
No, I don't. I don't, but that's if you're having trouble finding someone to do that, that's an important thing for us to know. We can brainstorm on that.
Yeah, go ahead.
Area are struggling with that. If you want to reach out, perhaps we have contacts or ideas in that area that could be helpful.
Good. Here's a question, and I think this one was missed. What happens to approved refugee children who arrive to live with a petitioning TPS parent who then loses TPS status due to the threatened impeding end of TPS for El Salvador?
Well, there is immigration and nationality. You know, there is. Sorry, that's not what I'm trying to say. I'm trying to say there's federal law. There's federal law on what are the different reasons that can justify termination of refugee status, and for someone who's actually been granted refugee status, they can't lose that refugee status based on the parent not having TPS anymore. So that's not one of the reasons. But, I mean, what will actually happen to them, right, is a much bigger question in terms of, are we talking about children who, depending on their age, could end up in foster care? Might the parent be deported? I mean, those are the questions, but their status, their refugee status, will not be at risk of being revoked based on the parent losing TPS.
Here's a question. I've heard that if we send our G28 directly to certain IOM offices, that we could get more direct information about status of individual cases. Is that true? And can folks make an expedited request for currently pending cases for kids in increasing danger?
I haven't heard that about sending G28s to IOM.
Yeah,
I think I would try what Darwenzi suggested about going to the national agency and asking them to seek updates. But I would want to say, in terms of expedite requests, definitely some cases have been and do get expedited, and maybe Darwenzi can talk about that too. But I have definitely. I understand that is also triggered by going to the national, kind of representative for the resettlement agency and having them, bring to the attention of PRM. Anything that can show for saying if that's because somebody is granted refugee status and they're, let's say, an unaccompanied child, then they should be eligible for URM, unaccompanied refugee minor foster care. They don't lose their eligibility for that simply because there's not a parent connection at that point.
Right, that's more like their eligibility to enter into the pipeline. We've not seen that fact scenario in similar contexts. So I guess the answer is that we don't know, but I agree with Lisa. It seems like there would be some kind of cause of action there. I think before they're granted refugee status, there's obviously vulnerability there because you have to, as part of the adjudication, when they're looking at refugee status, they do look at whether or not you rightfully access the program. And so if that's pulled before they're given refugee status, that might be a more difficult claim. Yeah.
But I don't know, maybe we should seek a specific answer on that from USCIS, and maybe that's something to include in the broader advocacy. in terms of processing the cases and ensuring a commitment to bringing over refugees, regardless of the status of their parent once they've been granted refugee status.
Darwency, let's see here, Lisa and Lara, we have about another 3 minutes, and I do want to be mindful of your time. You're both so very gracious in spending an hour and a half with us on the webinar here. Let's see, I think we have another couple of questions being asked. I see folks typing. In this limited time that we have, was there anything of importance, any piece of advice that you all wanted to provide?
Tony, I'm just seeing Lindsay and Eduardo's comments. Lindsay is just conveying her perspective on the status of the parent, and I do agree with that, that the parameters of the program, as we understand, are indicative of the status of the parent, and if the parent has lost status, then the refugee case cannot travel. In terms of Eduardo's question, Eduardo, unfortunately, we have stopped receiving, all RAs have stopped receiving reports in regards to the aggregate cases that we have filed for the Central American Minors Program, and we were disseminating that, and we were hopeful that we would be able to request an appeal. We did request an appeal to obtain that document again, but that is still in pending status. And so at this time, again, as I was mentioning before, if you have questions in regards to cases that are in process, you can contact us, and basically we will have to do this piecemeal and, connect with the RSC to get an update on the status of the case.
I don't know if you folks can answer this one. Carmen in New York is reporting that clinic assisted other groups in group processing for the program, for other programs, taking into consideration the number of families that needed the service. Is this something that others can do, group processing?
I mean, if you're asking about the resources, like, for example, to get together and do RFR clinics, is that what you're asking about, or re-parole kind of clinics?
It's the Catholic Legal Immigration Network is what she's referring to. So clinic was helping folks process their applications, I guess, as a group.
Yeah, I mean, I think it's a question for clinic, what they can put together. I mean, I've been trying to get information on the top parole cities, meaning where people who've actually been granted parole have entered, so that we can do some outreach in terms of hopefully putting together either clinics for re-parole and legal assessment options, or at least feed people into existing clinics. I think the RFRs are more complicated in some ways in terms of just really needing a fair bit of information from the child. The child's the only one who really knows how that interview went, and potentially the caregiver. And that there's a need for more kind of back and forth exchange. I don't think that, the RFR can't be put together entirely in a clinic. There's got to be follow-up, But if the clinic comes with people who are committing to cases and following up on them, I mean, I think it would be really beneficial, but I guess it's a question for a clinic whether they would do it.
Okay. And, with that, I'm going to go ahead and conclude our webinar today. Thank you, everyone on the webinar and on the computer for participating today. Special thanks to Darwency and Lara Finkbeiner with IRAP and Lisa Friedman with KIND. you folks have provided a lot of really important information, and we could probably stay on for another hour and a half with with the level of expertise you provide. But thank you very much, and for folks on the phone, on the webinar, we'll have the recording of the webinar, the slides, as well as resources that our presenters are going to provide. We'll have those available on the justiceforimmigrants.org website, hopefully by Friday of this week. Okay. Thank you all for participating today. Thank you to our presenters, and have a good rest of the week, everybody. Okay? Thanks. Bye.
Thank you.